Hello. I just wanted to talk to you for a moment about a situation that just came up for a parent who got in touch with me about helping her child who has severe food allergies and has a 504 plan regarding accommodations for food allergies, but the school is not following the 504 plan, and her child has actually even had to go to the hospital a couple of times because of contact with offending food. That's how severe the allergic reaction has been. The problem is that there really aren't good options for enforcing 504 plans or ADA violations under the current administration. It used to be that you could file federal complaints with the U.S. Department of Education Office for Civil Rights, where I did an internship in law school many years ago, or a complaint with the U.S. Department of Justice. And they have a civil rights division that would investigate and enforce issues like this. Unfortunately, the Education Department, as you probably know, has essentially been gutted. So there are no more personnel left to investigate complaints of 504 violations. And the Department of Justice has been ordered to freeze accepting new investigations of civil rights violations. So they're not doing the work anymore either. The only other option is a private right of action, which would mean filing a lawsuit in federal court, which could take a year or more easily, cost you maybe $40,000-$50,000 in legal fees, and you have no guarantee of winning. Far, far from it, in fact. So neither of those options is really a good option anymore. The thing to do is to try to get your child an IEP. And the reason for that is that you also have a right of action as a parent of a child with a disability under the Individuals with Disabilities Education Act. If you can find some kind of educational impact caused by the disability that requires specialized instruction, that means the services of a special education teacher. So if your child has a disability like a food allergy, for example, but there is no educational impact whatsoever, your child is a straight A student, a high flyer, this is probably going to be difficult for you to achieve. However, if your child has food allergies and there are accompanying issues, for example, social emotional issues, communication issues, anything that you can find that impacts your child in an educational setting in some kind of adverse way, you can make the argument that your child requires services of a special education teacher and possibly even related services such as counseling to address these issues, and therefore is eligible for an IEP. And the reason why that's beneficial is that there are additional enforcement mechanisms available to you as a parent to ensure that the IEP is being followed, such as an administrative law due process hearing that you can handle really on your own without the services of an attorney. It's faster, it's less expensive, and it's something that you, as a caring, concerned parent, can learn how to do yourself. And of course, I would put in a little plug for my course, the Parents Playbook for Special Education Success, because it does teach you how to get your child found eligible for an IEP, how to get the IEP drafted and followed correctly, as well as how to enforce the IEP once it has been created. So really, this is going to be your best option. If your child's school is ignoring their 504 plan, this is going to be the way to go, because there really isn't any enforcement mechanism left for 504 plans, unfortunately. I hope this is helpful.